unintended pregnancies. It doesn't create jobs. It doesn't improve the economic situations of our hometowns, and that's what we should be debating for hours and hours tonight. I yield back.
For what purpose does the gentleman from Colorado rise? The gentleman is recognized for 5 minutes.
I rise in support of the amendment to remove taxpayer dollars from Planned Parenthood. In my state of Colorado, the voters passed a state constitutional amendment by initiative about 30 years ago. It said no taxpayer dollars will go to abortion, whether directly or indirectly. We decided in Colorado that because money is fungible, giving taxpayer dollars to an organization that provides abortion, even if they say it doesn't go directly to abortion, does indeed ultimately fund it. This is because that taxpayer money frees up that organization's resources to be moved around on its books. Money is fungible. Taxpayer dollars enable Planned Parenthood to perform abortions. And the sentiment in Colorado is the same in the rest of America. Americans don't want to use taxpayer dollars for abortions. Until the day comes that Planned Parenthood stops performing abortions, it should not get another penny of taxpayer money. I urge my colleagues to support the Pence amendment. Mr. Chairman, I now yield the balance of my time to the distinguished gentleman from New Jersey, Mr. Smith.
Americans, especially policymakers, health officials, the media, and law enforcement, take a second and critical look at Planned Parenthood. Not only does Planned Parenthood vigorously lobby and litigate against parental notification and parental consent laws, thus enabling secret abortions for very, very young girls to be procured in their clinics. But now we've learned from recent undercover taped investigations at several of its clinics that Planned Parenthood employees were found to be more than eager to assist people posing as sex traffickers to procure abortions for underage girls. As the prime sponsor of the Trafficking Victim Protection Act of 2000, I found it appalling to watch Planned Parenthood personnel again and again and again offer to provide and facilitate abortions for hypothetical sex trafficking victims as young as 13. In light of a recent comprehensive study suggesting that 100,000 American girls, mostly runaways, are forced into prostitution each year, average age 13, the videotapes of Live Action, the NGO headed by Lila Rose that did the undercover work, is an engraved invitation for serious investigation by the Attorney General of the United States and law enforcement everywhere. And it further begs the question, why are taxpayers giving hundreds of millions of dollars each and every year to Planned Parenthood? Despite the best and slickest market branding money could buy, the stubborn fact remains that Planned Parenthood clinics are among the most dangerous places on earth for a child. And Planned Parenthood's own personnel are now taking a second look, many of them, and thanks to ultrasound, are clearly seeing what is being done to millions of children in the womb, like the 332,278 babies exterminated in Planned Parenthood's abortion clinics in 2009 alone. One of those abortion providers who took a second look and walked away is Abby Johnson, a former Planned Parenthood abortion clinic director. In her book, Unplanned, Abby Johnson exposes the duplicity and cruelty of what really goes on behind closed doors at a Planned Parenthood clinic. In it, she writes how she witnessed and assisted in an abortion of a 13-week-old baby by holding the ultrasound probe. And as she pointed out in the book, it was the first ultrasound-guided abortion at that facility. She writes in the book, "The details startled me at 13 weeks. You could clearly see the profile of the head, both arms, legs, and even tiny fingers and toes. With my eyes glued to the image of this perfectly formed baby, I watched as a new image emerged on the video screen. The cannula, a straw-shaped instrument attached to the end of the suction tube, had been inserted into the uterus and was nearing the baby's side. It looked like an invader on the screen, out of place, wrong. It just looked wrong. She goes on to write, my heart sped up, time slowed. I didn't want to look, but I didn't want to stop looking either. At first, the baby didn't seem aware of the cannula. It gently probed the baby's side, and for a quick second I felt relief. But I couldn't shake an inner disquiet that was quickly mounting to horror as I watched the screen. Remember, this is an abortion clinic director saying this. The next movement was a sudden jerk of a tiny foot of the baby as he started kicking, as if trying to move away from the probing invader. I move to strike the last word.
The gentleman's time from Colorado's time has expired. For what purpose does the gentleman from New Jersey rise?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
I thank the chair. As the cannula pressed in, the baby began struggling to turn and twist away. It seemed clear to me that the fetus could feel the cannula, and it did not like the feeling. And then the doctor's voice broke through, startling me. Beam me up, Scotty, the abortionist said lightheartedly to the nurse. He was telling her to turn on the suction. In an abortion, the suction isn't turned on until the doctor feels he has the cannula in exactly the right place. This abortion clinic director then went on to write, I had an urgent, sudden urge to yell, stop, to shake the woman and say, look at what's happening to your baby. Wake up, hurry, stop them. But even as I was thinking those words, I thought of my own hand and saw my own hand holding the probe. I was one of them performing this act of abortion. My eyes shot back to the screen. The cannula was already being rotated by the doctor, and now I could see the tiny body violently twisting with it. For the briefest moment, it looked as if the baby was being run like a dishcloth, twirled and squeezed. And then the little body crumpled and began disappearing into the cannula before my very eyes. The last thing I saw was the tiny, perfectly formed backbone sucked into the tube, and then everything was gone. The image of that tiny, dead baby, mangled and sucked away, kept replaying in my mind. What was in this woman's womb just a moment ago was alive. It wasn't tissue. It wasn't cells. This was a human baby fighting for life. A battle was lost in the blink of an eye. What I have told people for years, 8 years, as a clinic director at a Planned Parenthood clinic, what I have told people for years, Abby Johnson continues, what I believed and taught and defended is a lie. I ask members to read this book, Unplanned, and realize the scandal of the killing of these unborn children and calling it choice. Mr. Speaker, there is nothing whatsoever benign or caring or generous or just or compassionate or nurturing about abortion. Earlier, one of our colleagues called abortion healthy for the child. Abortion dismembers children piece to piece. Planned Parenthood's own fact sheet talks about D&E abortions done in during the second trimester period. Have you ever seen what a D&E is? The doctor goes in with forceps and this device and literally hacks that baby to death. Planned Parenthood itself says it takes 10 to 20 minutes to literally dismember that child. Then there's the shots in the heart. There's a group called late-term abortion and a doctor right here in this area that on perfectly healthy babies gives them cardiac sticks with either feticide poison or a burst of air which kills the unborn child. So it is not healthy for children, and we know for a fact it is not healthy for women either. Mr. Speaker, Mr. Pence's amendment simply seeks to end U.S. taxpayer complicity with this massive violence against children. Who we back, who we subsidize does matter, not just what, but who. Planned Parenthood does 330,000, more than 300,000 abortions each and every year. Each and every year. They are the largest provider, about a fourth of all the abortions in the United States. It is child abuse. It is time to take a second look at Child Abuse Incorporated. Support the Pence Amendment. I yield back.
For what purpose the gentlewoman from California rise?
Move to strike the last word.
The gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. You know, I had really planned to speak about something else, but the gentleman from New Jersey has just put my stomach in knots. Because I'm one of those women he spoke about just now. I had a procedure at 17 weeks, pregnant with a child that had moved from the vagina into the cervix. And that procedure that you just talked about was a procedure that I endured. I lost a baby. But for you to stand on this floor and to suggest, as you have, that somehow this is a procedure that is either welcomed or done cavalierly or done without any thought is preposterous. To think that we are here tonight debating this issue when the American people, if they are listening, are scratching their heads and wondering, what does this have to do with me getting a job? What does this have to do with reducing the deficit? And the answer is nothing at all. There is a vendetta against Planned Parenthood, and it was played out in this room tonight. Planned Parenthood has a right to operate. Planned Parenthood has a right to provide services for family planning. Planned Parenthood has a right to offer abortions. Last time you checked, abortions were legal in this country. Now, you may not like Planned Parenthood. So be it. There's many on our side of the aisle that don't like Halliburton. And Halliburton is responsible for extortion, for bribery, for 10 cases of misconduct in the federal database, for a $7 billion sole source contract. But do you see us over here filing amendments to wipe out funding for Halliburton? No, because frankly that would be irresponsible. I would suggest to you that it would serve us all very well if we moved on with this process and started focusing on creating jobs for the Americans who desperately want them. I yield back.
For what purposes does the distinguished Majority Leader rise?
Mr. Speaker, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Speaker, Planned Parenthood receives a third of its $1.1 billion budget from taxpayer dollars. The opposition to this amendment continues to say that this is not about federal funding of abortion, which the Hyde Amendment prohibits. We all know, however, that money is fungible. Taxpayer dollars are going to keep the lights on and the doors open and to pay for things which frees up money for abortions. Recently, Planned Parenthood has been caught red-handed in several different clinics, including one in my hometown of Richmond, aiding and abetting sex trafficking and prostitution of minors. Now, the other side continues to say that Planned Parenthood has a right to operate. They don't have a right to do that. You cannot argue that an organization that engages in patterns of conduct such as those revealed in the videos seen in clinics such as that in my hometown, you cannot argue that an organization like that cares about the rights of women and girls it purports to serve. So, Mr. Speaker, I ask you, why on earth are we given $363 million in taxpayer funds every year to Planned Parenthood? It is time to say no more. The time has come to respect the wishes of a vast majority of Americans who adamantly oppose giving taxpayer dollars for abortion. That is why I support this amendment, Mr. Speaker, and that is why I urge my colleagues to do the same. And I yield back.
For what purpose does the gentleman from Rhode Island rise?
Mr. Chair, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, I'm new to this body, but I was just elected to the Congress of the United States, and what I heard during the course of my campaign is the urgency to get people back to work, to strengthen the middle class, to create jobs, and to deal with the deficit. And we've just spent the last 3 hours under the cloak of deficit reduction. My friends on the other side of the aisle have pushed this very extreme amendment, which is targeting women's health care and women's health care providers. This ideological attack comes at the expense of our nation's women. It's an attack on Planned Parenthood health centers and will put the lives of millions of women at risk. Millions of women who seek and receive health care at Planned Parenthood centers all around this country. Every year, Planned Parenthood doctors and nurses carry out nearly 1 million life-saving screenings for cervical cancer and 830,000 breast exams. Its health centers provide contraception to nearly 2.5 million patients, and nearly 4 million patients are treated for sexually transmitted infections, including HIV. Planned Parenthood provides preventive health care, and that represents 90% of its work. We already have a federal prohibition against using federal funds for abortion. Not a single penny intended or targeted by this amendment is used to terminate a pregnancy. What we should be talking about is getting the American people back to work, creating jobs, responsibly dealing with our deficit, and doing everything we can to strengthen the middle class. That's what we were sent here to do. That's what we should be doing. And I urge my colleagues to reject this amendment so we can get back to the important business of putting Americans back to work. I yield the balance of my time to Susan Davis. I have to stay.
Gentleman yields back.
No, I yield the balance of my time. Ms. Davis.
Gentlewoman from California is recognized.
Thank you, Mr. Speaker. I bet the American people are really surprised tonight, because we are debating a continuing resolution when they are facing tremendous challenges. And we should be thinking about them and the challenges that they face. We should be talking, as my colleague has said, about how to save money and how to create jobs. But instead, we're debating an amendment that will do neither. It will do neither, and it will undermine women's health. This amendment denies women access to reproductive care, and it attacks the health providers that they rely on in their communities. These are health providers that are serving the underserved, and we are spending the evening attacking them. Planned Parenthood plays a critical role in our nation's health care system. We know that. These clinics help over 3 million Americans every year, and more than 90% of the care they provide is preventative. Preventative, what does that mean? We have many physicians here. What does that mean, preventative care? Preventative care means that men and women do not have to go through more costly procedures, and even that their lives can be saved. 1 in 5 American women have been to a Planned Parenthood health center for services like breast cancer screening, cervical cancer screening. We've talked about all that this evening. I cannot let San Diego families lose these valuable services. I will not let that happen, because I know that when women have better access to these services, it leads to healthier outcomes for both the women and their children. But this amendment proposes to cut these services under the guise somehow of being fiscally responsible. That's not true. What I know about my state of California is that Title X supported centers saved $581,890,000 in public funds in 2008 alone. So let's talk about saving money. Let's talk about creating jobs. Let's not talk about constricting women's access to health care. Vote no on the Pence amendment.
Gentleman from Rhode Island.
I yield back the balance of my time.
Gentleman yields back. For what purpose does the gentlelady from Tennessee rise? The gentlelady is recognized for 5 minutes.
Thank you, Mr. Speaker. You know, this has been a good debate this evening, and I want to thank the Speaker and Mr. Chairman, I thank you also, for the time that you have allowed for this body to stand and have this debate. And there's been a lot said. A couple of things I think do need to be corrected. We are thinking about the American taxpayer, and we are thinking about our responsibility to the taxpayer. This is not a debate about a vendetta. It is not a debate about Planned Parenthood. It is not a debate about something that is extreme. What this is tonight is a debate about our stewardship and our responsibility to the American people. Our discussion tonight, and I thank Mr. Pence for his leadership in this, is how we fund this government in a responsible manner, how we get this government back on track. And the taxpayers are weighing in, and they are reminding us that we, the members of the House, are the keepers of the purse of this great nation, and that it is important that we have these discussions. And they want us to do it respectfully, they want us to do it responsibly, and they want us to make wise decisions. And quite frankly, Mr. Speaker, to give $363 million in funds to an organization that has conducted itself. Mr. Speaker, the House is not in order.
Gentlelady is right. The committee is not in order. The committee will come to order. Gentlelady may continue.
Mr. Speaker, to give $363 million in taxpayer funds to an organization that has not conducted itself in a manner that suggests they deserve those funds is not respectful of the taxpayer. I want to go back to what Mr. Pence said at the beginning of the debate. This is a debate about who pays. No one is saying that Planned Parenthood has to stop operating or has to stop being an advocate for abortion. What we are saying is that the American taxpayer should not have to foot the bill, especially for an organization that is facing criminal charges, that has admitted wrongdoing, that is accused of endangering the safety of minors. The American taxpayer should not have to spend millions of taxpayer dollars on this. I encourage my colleagues to stand for appropriate stewardship of the taxpayer dollars and to support and vote yes on the Pence amendment. I yield back.
Gentlelady yields back. For what purpose does the gentleman from California rise?
Strike the last word.
Gentleman is recognized for 5 minutes.
I had not intended to get into this particular debate.
This would end the debate, and I would hope that that agreement could be agreed to.
The gentleman from California yields back. Who seeks recognition?
Well, we got to vote first.
The question is on the amendment offered by the gentleman from Indiana. Those in favor say aye. Aye. And those opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman,
The gentleman from Indiana.
then I request the yeas and nays.
This gentleman asked for a recorded vote.
Request, Mr. Chairman.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Indiana will be postponed.
Mr. Chairman,
For what purpose does the gentleman from Kentucky
I
rise?
move the committee do now rise.
The question is on the motion to rise. Those in favor, say aye.
Aye.
Those opposed, say no. In the opinion of the chair, the ayes have it. The committee will now rise. Chairman. Mr. Speaker, the Committee of the Whole House on the State of the Union, having had under consideration H.R. 1, directs me to report that has come to no resolution thereon.
The Chairman of the Committee of the Whole House on the State of the Union reports that the committee has had under consideration H.R. 1 and has come to no resolution thereon. For what purpose does the gentleman from Kentucky rise?
Mr. Speaker, I ask unanimous consent to proceed for 1 minute out of order.
Without objection.
Mr. Speaker, we have had, I think, a very elevated week of debate about the entire government. This is one of those very rare occasions when the Congress, for a single span of time, debates practically every element in the federal budget. That is a very, very rare occurrence. And I think we've had a very elevated debate on both sides of the aisle. I want to commend all the members, Republicans and Democrats, for a good debate on a whole host of issues. We are making progress, but we have a ways yet to go. I want to thank Mr. Dix, the ranking member of this committee, for being very, very, very helpful in moving this process along. And I have to pause, Mr. Speaker, and remind us all of how important staff is to what we do. This staff has been fantastic. We have been working with Mr. Dix and leadership on both sides to try to find a way to make the debate concise and reasonable in time. And we have reached an agreement that we want to propound to the body now, which we think is fair, and will give everyone their opportunity to make their presentations in due course of time. So, Mr. Speaker, I ask unanimous consent that during further consideration of H.R. 1 in the Committee of the Whole, pursuant to House Resolution 92, no further amendment to the bill may be offered except pro forma amendments offered at any point in the reading by the Chair or ranking minority member of the Committee on Appropriations for the purpose of debate, and except and these amendments: number 8, 13, 19, 23, 38, 42, 46, 47, 48, 49, 51, 54, 55, 79, 80, 83, 88, 89, 94, 99, 101, 109, 117, 120, 126, 127, 137, 141, 144, 145, 146, 149, 151. Do I hear 154? 159, 164, 166, 172, 174, 177, 185, 199, 200, 207, 216, 217, 233, 241, 246, 251, 255, 261, 263, 266, 267, 268, 274, 280, 281, 296, 323, 329, 330, 331, 333, 336, 342, 344, 345, 348, 367, 369, 377, 392, 396, 400, 401, 405, 408, 409, 414, 424, 429, 430, 439, 445, 448, 463, 464, 465, 467, 471, 480, 482, 483, 495, 496, 497, 498, 504, 507, 515, 519, 524, 525, 526, 533, 534, 536, 543, 548, 552, 560, 563, 566, 567, 569, 570, 577, 578, and 583. Amendments 27, 278, 466, and 545, each of which shall be debatable for 20 minutes. Amendments 104 and 540, each of which shall be debatable for 30 minutes. And Amendments 273, which shall be debatable for 40 minutes. Amendment 575, which shall be debatable for 60 minutes. And that each such printed amendment may be offered only by the member who caused it to be printed in the record or a designee, shall not be subject to amendment except that the chair and ranking minority member of the Committee on Appropriations each may offer one pro forma amendment for the purpose of debate, and shall not be subject to a demand for division of the question in the House or in the Committee of the Whole. And that except as otherwise specified in this order, each printed amendment shall be debatable for 10 minutes, and all specified periods of debate shall be equally divided and controlled by the proponent and an opponent. Mr. Speaker, I ask unanimous consent, and I yield to the gentleman.
Reserving the right to object, and Mr. Frank I will be prepared to take a floor in a second. I just want to also join the chairman in congratulating the staff. This is the hardest working staff that I've ever seen in my career. The effort that's put in on a bipartisan basis. This is the most cohesive and professional staff that I've seen. And I've been up here on the Hill for over 40 years. And I just want to say that Jennifer Miller and David Pomerantz worked very hard to put this agreement together. We asked for some additional time. Our members wanted a chance to express themselves on some of these very important and sensitive issues that are in this legislation. But it is my judgment that we should not object, that we should accept this agreement and proceed forward and finish this legislation.
Is there objection? Yes, sir. Gentleman recognized.
Mr. Speaker, I am, I guess, a dissenter in this orgy of self-congratulation, and I want to explain why, and I may not object if I have a chance to explain why, but if I can't explain, I have to object, so that's the choice. I either explain or object. I object not to the UC at this point, but to the self-congratulation that the majority is engaging in because they said they had such a, quote, open process. In fact, the refutation of that was best stated by the gentleman from Kentucky. He just said, we've debated the whole government. Yes, we have, and very inappropriately. To debate the whole government and to debate fundamental policy issues under the guise of a budget, under the constraints of a budget debate, in not a whole week, 2.5 days so far, maybe we'll get a third day, we have dealt with the most fundamental questions. In the jurisdiction of the committee on which I serve, issues came up under great constraint. The reform bill of last year has been damaged by what was done here. Fortunately, it will never become law. And we were constrained because we had to choose between the SEC and the IRS. That's not the way to legislate. This was not an open process. Yes, you could offer amendments. You could offer amendments in a very narrow compass. You could offer amendments according to the jurisdiction of subcommittees. The jurisdiction of subcommittees is somewhat accidental. It doesn't determine public policy. And yes, we are talking about it now. We are boasting about debating the whole government. Did you, my colleagues, listen to the UC? You'll get to debate whole aspects of the government tomorrow for 10 minutes. We are the model of democracy. The next thing you know, they'll be rioting in parts of the world so they can have 10 minutes per issue to debate fundamental issues. This is a travesty. I very much objected to this procedure. My leadership, for which I have great respect, had asked me if they could go forward. I am prepared to allow that because of some conditions. One is that I am confident that this awful, distorted, ill-thought-out process has produced a bill that will never see the light of day. And by the way, no one should be surprised. We are now going to recess after we finish with all these other parts of the government in 10 minutes per issue. Oh, up to an hour for a couple of important ones, 20 minutes for some only moderately important ones. The Senate will then get this with 4 days left before it expires. Now, no one realistically thinks this is going to happen, so perhaps some of the constituencies were mollified by this show. But I want to stress again, this has been an awful procedure. The gentleman from Kentucky is right. We have debated the whole government, fundamental issues that go far beyond budgetary issues, in 3.5 days. We will have debated fundamental issues in 10 minutes. This is openness. This is a travesty of the democratic process. So, Mr. Speaker, because I have been given a chance to explain why I think this is a terrible process, why I am going to say now I don't expect the Senate to accept this. We will have to come back and do it again. There'll have to be, I assume, a short-term extension. I want to give notice now to all parties. I will object strenuously at every procedural opportunity to any effort to repeat this travesty. So respect to the ranking member, leader, and to others, and to people who work so hard, and to the poor, long-suffering staff, yes, I will remove my reservation, and I will not object. Having made it clear, once the Senate gives this awful product an appropriate burial, I will not be a party to its resuscitation. Mr. Speaker, I remove my reservation.
What purpose does the gentleman from Kentucky rise?
Mr. Speaker,
Texas.
I ask unanimous consent to proceed out of order for 1 minute.
Mr. Speaker, I reserve the right to object.
This is gentleman from Texas.
Was reserving the right to object because
recognized.
Just sit here and listen after having spent 4 years dealing with the most closed Congress.
Gentlemen would suspend. House is not in order. Would everybody take your conversations off the floor, please? Gentlemen may resume.
Having spent the last 4 years dealing with the most closed Congress, the last Congress, in fact, with more closed rules than any Congress in American history, and then to be lectured about what is a travesty is a travesty. That's the real travesty. That many closed rules, and you come down here and want to tell us what is awful? Try standing here for the last 4 years and dealing with closed rule, closed rule, closed rule, no amendments. We're not going to let you represent your people because we're going to cram everything down. That's a travesty. I will not yield. I'll listen to you. Let's get on with a democratic process because that's what it is when you get to hear from both sides. We heard from one side. We heard travesty several times. And now we'll get back with the democratic process. And with that, I'll withdraw my reservation.
The gentleman withdraws. Without objection, so ordered.
Speaker.
What purpose does the gentleman from Kentucky rise?
I ask unanimous consent to proceed out of turn to discuss the schedule for the evening.
Without objection.
Now that we do have the UC in place, we intend to take up 5 amendments this evening, this morning. There will not be recorded votes this evening, so members that wish to would be able to leave, but we will debate 5 of the amendments under the UC and roll the votes until tomorrow. Mr. Speaker, I also want to add briefly my thanks, especially along with Mr. Dix, our thanks to Jennifer Miller on our side and David Pomerantz on the other side, who are the ones who crafted this UC very diligently and very accurately, and we want to thank them especially for their work. I yield back.
Thank you. But pursuant to House Resolution 92 and Rule 18, the Chair declares the House in the Committee of the Whole on the State of the Union for further consideration of H.R. 1. Will the gentleman from Georgia, Mr. Gingrey, kindly resume the chair?
The House is in the Committee of the Whole House on the State of the Union for further consideration of H.R. 1, which the clerk will report by title.
A bill making appropriations for the Department of Defense and the other departments and agencies of the government for the fiscal year ending September 30th, 2011, and for other purposes.
When the Committee of the Whole rose earlier today, a request for a recorded vote on Amendment number 11, printed in the congressional record offered by the gentleman from Indiana, Mr. Pence, had been postponed, and the bill had been read through page 359, line 22. Pursuant to the order of the House of today, no further amendment may be offered except those specified in the previous order, which is at the desk. For what purpose does the gentleman from Alaska rise?
Mr. Speaker, the House is not in order, and I do have an amendment to the desk titled 533.
The gentleman will suspend. The committee is not in order. Will all members on both sides of the aisle please take your conversations to the cloakroom and off the floor? The gentleman from Alaska is recognized and may continue.
Mr. Speaker, I do have an amendment to the desk, 533.
The clerk will designate the amendment.
Amendment number 533, printed in the congressional record, offered by Mr. Young of Alaska.
Pursuant to the order of the House of today, the gentleman from Alaska, Mr. Young, and a member opposed each will control 5 minutes. The chair now recognizes the gentleman from Alaska.
Mr. Speaker, I ask the unanimous consent to revive and extend.
Without objection.
Mr. Speaker, we must explore for and develop the Arctic resources in an environmentally safe and substantial manner. We must allow that exploration work to proceed without bureaucratic impediments. This amendment accomplishes both. This amendment would limit funds in the bill from being used by the Environmental Appeals Board, EAP, to invalidate any permit issued by the Environmental Protection Agency, EPA, for activities on the Arctic Outer Continental Shelf, OCS. The EPA is an extension of the EPA that hears administrative appeals pertaining to permit decisions and civil penalties.
I at least want to hear what the gentleman...
The gentleman will suspend. The committee is not in order. Would the members please take their conversations off the floor? The gentleman deserves to be heard. The gentleman from Alaska may continue.
The EPA is an extension of the EPA that hears administrative appeals pertaining to permit decisions and civil penalties decisions of the agency. Very frankly, EPA is populated by environmental appeals judges who are lawyers associated with EPA or Justice Department. This amendment does not circumvent the EPA's authority. Instead, it continues to give permitting decisions to the professionals in the regional offices. What this amendment will do is remove the ability for lawyers to overrule EPA permit writers. Over $40 billion have been invested in trying to drill exploratory wells to a date, and not a single well has been drilled because of EPA air permits. Mr. Speaker, if I must say, this is an example where an agency is trying to issue the permits correctly, but they have a board that can listen to someone who objects to it that rules against them. And we have, in fact, had a little over 680 leases in the Arctic Ocean. Oil that we need being held up by bureaucrats. We will do this safely. The air will be clean. They're 80 miles from any human other than those that work on these ships. And if you believe it's right to buy this oil from overseas, shame on you. Again, we are spending close to $40 billion this year or more buying foreign oil. 72% of our oil is coming from overseas. The right thing to do is allow us to take and explore and find out if that oil is there, and if it is, to develop it. Now remember, we're not the only ones in the Arctic anymore. Iceland, Greenland, China, Russia are all drilling. We're the only ones not involved, yet we have the best equipment, the best environmental records in the Arctic. We have the proper equipment to do it safely. It's being held up by bureaucrats that don't want to issue the permits. EPA has said it's all right, but the review board says no, it's not, within the agency itself. All this says, if they have the permit issued, then it should go forth, and let's get on to serving this country as we should for the benefit of this nation, for the benefit of those, so we don't have to go to war over in the Middle East over oil. So if you don't like what's going on there, let's support this amendment. I believe it's the correct thing, and I reserve the balance of my time.
The gentleman reserves. For what purpose the gentleman from Virginia rise?
Mr. Chairman, I rise to claim the time in opposition.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. The gentleman's amendment stops funding for, and I will quote, the Environmental Appeals Board to consider, review, reject, remand, or otherwise invalidate any permit issued for outer continental shelf sources located offshore of the states along the Arctic coast. Now, the gentleman has shared with us a specific situation, but his amendment goes considerably beyond that. The Appeals Board is the final decision maker on administrative appeals under all major environmental statutes that the Environmental Protection Agency administers. It's an impartial body, independent of all agency components outside the immediate office of the administrator. To support this amendment is to take away people's right to petition their government. This is an impartial board that looks out for the regular citizen. In fact, they just took great care and ruled on the side of Alaskans and courageously ruled against EPA's issuance of a permit to shell oil. I thought the gentleman and his side of the aisle would take sincere joy in any decision ruling against EPA. But that's not the case, apparently. I guess EPA is okay as long as it doesn't use any federal funds and rules exactly the way that you want them to. And in fact, EPA did rule the way that the gentleman wants. It's just that we have an appeals board. That appeals board is there for good reason, has been for some time. Now, I don't have to tell the gentleman, but I think the other members of this body should know that the Environmental Appeals Board found that EPA's analysis of the effect on Alaskan Native communities of nitrogen dioxide emissions from the drilling ships was too limited, ordered the agency to redo the work. It doesn't mean that they can't drill. The analysis is incomplete. We should let that legal process work and stop interfering in long-standing regulatory and administrative processes. The amendment will be seen as an assault on the environment and an affront to the Alaskans who engaged in this case. I'm disappointed that the gentleman's position would appear to favor big oil over the small Alaskan villages that are being protected in this reconsideration. It doesn't mean that there won't be drilling. It simply means that the analysis to enable that drilling needs to be full and complete. And at this point, I would urge defeat of the amendment and reserve the balance of my time, Mr. Chairman.
The gentleman reserves...
Parliamentary inquiry. How much time do I have left?
The gentleman from Alaska has 2 minutes left.
2 minutes left. I'll take 30 seconds. I want to suggest one thing. The Native communities in Alaska support this. They support drilling. I've had them in my office. And to say that, I represent that state, not Alexander, Virginia. And they've come to me and say, we need it. So at this time, I yield to the gentleman, the chairman of the Appropriation Committee, Mr. Simpson.
The gentleman from Idaho is recognized.
I thank the gentleman for yielding. Beginning in 2005, the Shell Oil Company purchased leases in the Beaufort and the Chukchi Seas located within the Arctic Outer Continental Shelf. The company paid over $2.1 billion for these leases, these lease rights, a reflection of the potentially vast reserves off Alaska's coast. Shell applied for air permits from the EPA for its Beaufort leases in 2006 and for the Chukchi in 2008. The company went through a lengthy and burdensome administrative process. Shell's permits were initially approved but subsequently overturned by the EPA's Environmental Appeal Board. Last year, the Appropriations Committee addressed the problem by including language in the FY 2010 conference report, specifically directing the agency to allocate sufficient funds and personnel to process the OCS permits in a timely manner. This simply did not happen. The company is effectively at square one after spending millions of dollars and thousands of man-hours. Shell announced just this month that it had canceled plans for drilling in the Arctic in the 2011 drilling season, which is a very short drilling season. They have spent millions on this and done everything by the book. And the appeals board has decided that because they should have foreseen that the rules were going to change, that they shouldn't have issued these air permits. I think it's an overreach by the EPA and by the appeals board, and I support this amendment and would encourage my colleagues to vote for it.
Gentleman's time has expired. The gentleman from Virginia has 2 minutes remaining.
Thank you, Mr. Chairman. Mr. Chairman, I would underscore some points previously made. Number one, we are not taking a position on the merits of this case. It may very well be. I would not be surprised, in fact, personally, that ultimately the drilling off the Arctic coast would be approved. But this is like taking a case to the district court. The district court agrees with you, and then the plaintiff appeals. Goes to the appeals court disagrees or says that there needs to be more information. That's exactly what this appeals board did. Now, presumably that information is being gathered, it will be presented, and when it is, I don't know why the appeals board would not agree with the EPA decision. The problem with this amendment is we're setting a precedent to say if we don't like the appeals board, we like the district court decision, which is in this case EPA's decision, then we accept EPA's decision, ignore that appeals process. That's what we're opposed to. It seems to me we ought not be legislating that kind of judicial decision that affects many people's lives and incomes, clearly, and the environment without a full hearing. What's going to happen if this legislation were passed is that the decision-making process that allows this drilling will be suspect, and a permit will not be able to be fully issued without reservation. So for that reason, I would suggest that the right thing to do is to defeat this amendment, Mr. Chairman.
Gentleman yields back. The question is on the amendment offered by the gentleman from Alaska. Those in favor say aye, and those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to.
Mr. Chair, I'd call for a recorded vote on that.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Alaska will be postponed. For what purpose does the gentleman from New York rise?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Mr. Chairman, I rise as designee of the gentleman from Michigan, Mr. Conyers, and please offer that amendment.
The clerk will designate the amendment.
Number 524.
Amendment number 524, printed in the congressional record, offered by Mr. Nadler of New York.
Pursuant to the order of the House of today, the gentleman from New York, Mr. Nadler, and a member opposed. Each will control 5 minutes. The chair now recognizes the gentleman from New York.
Thank you, Mr. Speaker. Mr. Chairman, I now yield myself such time as I may consume.
The gentleman is recognized.
Thank you, Mr. Chairman. This is a bipartisan amendment sponsored by Mr. Conyers, Mr. Paul, myself, and Mr. Jones. The amendment would prohibit the use of any funds made available in this Act to make an application for what is commonly known as a Section 215 order requiring the production of library circulation records, library patron lists, book sale records, or book customer lists. The amendment is very narrowly drawn to protect the privacy of all Americans from unwarranted governmental investigation in an area directly related to their beliefs and private thoughts. What we read, where we read, what we listen to, our interests, the type of information we seek, our private tastes in art and music all tell a great deal about us. The right to be free from the prying eyes of government in these areas is absolutely necessary to protect our rights of free speech, religious liberty, liberty of conscience, freedom of association, and political freedom. This amendment will not prevent the government from obtaining this type of information, provided it obtains the constitutionally required warrant. What it will stop is the use of 215 orders, which are issued by the Secret Foreign Intelligence Surveillance Court under a standard so loose it is almost impossible for the government to get turned down, instead of the normal warrant. In fact, the secret court has become a virtual rubber stamp for the government. The amendment also will not stop the use of Section 215 orders in other investigations, such as surveillance of computer communications, even if conducted in libraries. Section 215 authorizes the government to obtain, quote, any tangible thing, close quote, so long as the government provides a, quote, statement of facts showing that there are reasonable grounds to believe that the tangible things are relevant to a foreign intelligence or international terrorism or espionage investigation. This would include business records, library records, tax records, educational records, or medical records. Before the enactment of Section 215, only specific types of records were subject to the orders issued by the secret court, and the government had to show, quote, specific and articulable facts giving reason to believe that the person to whom the record pertains is a foreign power or an agent of a foreign power, close quote. In other words, specific reasons to believe that the person you are talking about is either a foreign agent or a terrorist. This dragnet approach allows the government the dragnet approach of Section 215, which does not need those specific facts, allows the government to review personal records even if there is no reason to believe that the individual involved has anything to do with terrorism. This poses a threat to individual rights in the most sensitive area of our lives, with little restraint on the Congress. While Congress has decided to extend the life of Section 15 that does all these things for the next few months, during which I hope we can take a closer look at it, and if not reform it, then do away with it, I think it entirely inappropriate and necessary for us to provide some reasonable protection for these very limited and sensitive areas, in effect cutting out library records from the Section 215 extension that we've just voted. Do not believe the scare tactics of this amendment might impede investigations and might make us vulnerable to terrorism. The government has many tools with which to investigate terrorism and other types of wrongdoing. In fact, Section 215 is rarely used. Search warrants and other investigative tools would still be available to the government, but in any event, most of Section 215 is unaffected by this amendment and will continue. This amendment pertains only to library records. When we last considered this amendment, a number of years ago, it passed this House overwhelmingly with bipartisan support. Today, Representative Conyers and I offer it with two Republican colleagues, the gentleman from Texas, Mr. Paul, and the gentleman from North Carolina, Mr. Jones. I urge my colleagues to support this amendment, dealing only with the library records aspect of Section 215, and I reserve the balance of my time.
The gentleman reserves the balance of his time. For what purpose the gentleman from Virginia rise?
I rise in opposition to the amendment.
The gentleman is recognized for 5 minutes.
As the gentleman from New York knows, the Congress is considering temporary extension of the same Patriot Act authorizes that are targeted in this amendment. The reauthorization process, not in this CR, is the proper venue to consider any changes to existing intelligence gathering laws. Applications for FISA orders seeking library circulation records and book sales records may only be approved by the Director of the Federal Bureau of Investigation, the Deputy Director of the Federal Bureau of Investigation, or the Executive Assistant Director for National Security. And this authority cannot be further delegated. There is absolutely no evidence that this authority has been abused or misused to unlawfully acquire library or business records. This prohibition could create a safe haven for terrorists to utilize Americans' libraries and bookstores to conduct research or communicate with each other. I urge my colleagues to vote no and reserve the balance of my time.
The gentleman from Virginia reserves. The gentleman from New York.
Mr. Chairman, how much time do I have left?